Hi, and thanks very much for joining us for our second installation in Estate Planning 101. I am Dan Broccoli. I'm with Vanilla. I head up content here, and I've got two great guests, Dominic Cazzetto, who is a financial advisor at Advice Period, and Stephen Wallace, who is an attorney and partner at Accelerant Law. Thanks both very much for being here.
Thanks.
So let's just jump right in. We're going to talk a little bit about the foundations of basic planning here in this course. And the third course, we'll talk about the more advanced stuff. We're going to talk about intestacy, core documents, wills, healthcare directives, and that sort of thing. And then we're going to talk a bit about trust versus wills and when you might need a trust. All right, jump right in here. Stephen, can you talk us through these essential documents, these core documents here?
Yeah, of course. So these are kind of documents that everybody should have regardless of their net worth. And these documents are going to be applicable during your lifetime, but when you're unable to make your own choices at that point. So usually when somebody becomes incapacitated. And there's kind of three sets of documents depending on the state where you live. There's the general durable financial power of attorney. So this document appoints an agent to make financial choices for you if and when you're unable to make your own financial choices, okay? Then there's the healthcare power of attorney and the advance directive. In some states, it's a single document. In other states, it's two separate documents. But big picture, the healthcare power of attorney appoints an agent to make healthcare choices for you if and when you're unable to make your own healthcare choices. So I would say most married couples are appointing their spouse as their primary agent and then a successor. And the same thing for the general durable financial power of attorney. Most married couples are appointing their spouse as their primary agent and then a successor agent as well. So usually two people. And then for the advance directive or living will, that's kind of a direction to your healthcare provider and to your agent with respect to how you want to be treated in terms of end of life care, right? So if you get to an end of life point where really there's no hope of you recovering, you can tell them, kind of how you want to be treated from the spectrum of, I want to do whatever it is to be kept alive no matter what, to, I want to be treated with dignity, but I want to allow for my natural death to occur. And you can say, give me a lot of medicine, give me pain relief. I want to be, water, food, nutrition, those kinds of things. So from my perspective, one of the real added benefits to doing this for during your lifetime and for your family is that it provides clear direction to your agents on one, how you want your financial matters handled, but also more importantly for a lot of people, how you want your healthcare matters handled. And, just to give you an example, we had a client who had, a healthcare power of attorney and an advance directive, and they were coming towards the end of their life, right? And so 3 children, one of the children was appointed as the agent, and, dad wanted to be treated with dignity as he passed away, but he wanted to allow for his natural death to occur. And one of the daughters really wanted any kind of measures taken to keep dad alive. And so the one sibling could turn to the other sibling and say, look, this is what dad wanted. He clearly laid it out in his, advance directive. And so this is the choice that we're going to make as a family. And it provided a lot of solace and a backstop for that sibling who had to make the tough call with respect to, dad's ultimate decision. But it took the burden off of that sibling, and they didn't have to think like, is this really what dad would have wanted to happen? They knew what their father wanted to happen.
It's really important. Dominic, from an advisor perspective, these are difficult conversations to have. How do you approach them? And what is the importance of approaching clients with these documents?
Well, as Steve mentioned, they're, and by the name, essential. So you really need to have them at any level of net worth. For kids over the age of 18, that's one of the most often overlooked things that we find when we're speaking with our clients, because parents don't often realize that if they don't have an advanced healthcare directive or durable power of attorney for their children, and their children are unable to make financial decisions or approve for them to receive information about the individual's healthcare or make decisions about their healthcare, then they won't be able to. Instantly when someone turns 18, you lose that right as a parent, and a lot of parents don't realize that. So it's a very common conversation that we have with clients of children who are unmarried, regardless of net worth. This is also really important because it gives us kind of a view into who the responsible parties are. The client views as their kind of trusted people in their life. And And so what we'll often do is we'll use a tool like Vanilla to show the client who the fiduciaries are that are in charge of the advanced healthcare directive and durable power of attorney, just so that they ensure that those are the right people and that the wishes are going to be carried out the way that they expect them to.
Right. All right. Important stuff. So let's talk a little bit about intestacy. Stephen, you want to walk us through what this is and why we should care?
Yeah, of course. So intestacy is if you were to die without a will, how are your assets going to be divided, right? And so if you don't have a plan in place, if you don't put pen to paper and make decisions, then the state will decide for you. There's a state statute that specifically lays out who's going to receive your property and when they're going to receive it. And I would say, typically it's depending on the state, it all varies, but for most states, it's some portion, if you're married, some portion goes to your spouse, and if you have children, some portion goes to your children. I would say that's not reflective of most married couples' intention, right? Most married couples say, I want my spouse to receive all the property after I pass away, and then after we both pass away, the kids get it, right? So totally disrupts the family dynamic there, one, if you rely on the intestacy statute. And then for people who, may not have children or may not be married, then it gets really crazy. It can go, up to your parents if they're still living, if not to your parents, then to your siblings, and then further along lineal lines until somebody who you're blood related to gets the property. And so, from an estate planning perspective, there's people that they call laughing heirs, right? So you hear the story about somebody who's very wealthy, but they have no family members, nobody close to them, and they pass away without a will. And then they'll get a letter from somebody, a very distant relative will get a letter from a lawyer like me who says, you're the closest living heir to this person and you've just received all of their money, right? And so by not putting an estate plan in place, that wealthy person wasn't able to direct their assets to the people they otherwise probably intended to benefit, whether it be friends, charities, religious organization, whatever it may be. You got to put pen to paper or you're going to leave it up to the state.
Great. Anything to add, Dominic? Tell us. It's pretty straightforward. Yep. Appreciate that. All right. So we talked about the essential documents. Let's get into these dispositive documents. Will, pour over will, and revocable trust. Stephen, can you walk us through these?
Yeah, of course. So this is the other side of what we just discussed in intestacy. So if you die with a will, it's called dying testate, right? So you decided, I'm going to put pen to paper. I'm going to make the choice on where my assets are going to go after I pass away. And so there's kind of two different camps in dispositive documents. You can have either a last will and testament, or you can have what we call a pour over will into a revocable trust structure. They both dispose of your assets. It's just kind of a different flavor for each of them. So, a last will and testament is a legal document that allows you to decide who's going to receive your probate assets after you pass away. So what's a probate asset, right? A probate asset is an asset that's titled in your individual name when you pass away. It doesn't include things that we discussed in section 1, such as non-probate assets. So retirement benefits, life insurance, payable and death accounts. Those are all going to pass via operation of the contract between you and the institution. In a last will and testament, people are going to name a executor or a personal representative to oversees the administration of their estate. So they make sure that whatever property you owned in your name is given to the people that you tell them to via the written instrument. And then for a lot of people who have children, you're going to name guardians in your last will and testament. So you're going to name, if you're married, you and your spouse both pass away, who do you want to watch your children, care for them until they reach the age of majority in your state? The similar idea with a pour over will into a revocable trust structure. So basically what that structure says is you tell whoever you appoint as your personal representative or your executor under your will is any assets that are titled in my individual name, give them to the trustee of my revocable trust. And then the trustee of your revocable trust will deal with the disposition of all of your assets. So they will give the assets to who you intended under your revocable trust structure. And so a trust agreement is very similar to a last will and testament. It's a legal arrangement established for an individual that we call the settlor or the grantor of the trust, gives legal title to property to the trustee pursuant to the terms of that agreement. And so a revocable trust, similar to a will, can be updated at any point during your lifetime. It can be amended, changed at any point in your lifetime. So even though you have a view today on what you want the disposition of your assets to be, you can change it tomorrow, 5 years from now, as many times as you want. I have some clients who change them, it seems like on a weekly basis. So very flexible documents, but these are kind of your dispositive documents. They're going to handle the disposition of your assets after you pass away.
Great. So you mentioned probate assets and non-probate assets. Many on the call will know what probate is, but could you just give a little bit of a refresher for those who might need a refresher on what is probate and what happens when a will goes through probate?
Yeah, absolutely. So when you pass away, if you have a will and you have assets that are titled in your individual name, then they're going to have to go through probate. And probate is just a legal process where the person you appointed as your personal representative or your executor goes down to the local courthouse. They get appointed by the court as your personal representative or executor, and they're given letters testamentary. And those letters basically empower them to step into your shoes and take control of your property and administer your estate, which means paying all of your debts off, paying any taxes that may be due, and then transferring assets from your name into the name of the intended recipients of your assets. And depending on your state, probate can be a timely and costly process to go through. And so that's why, and we'll get into it a little bit later, some people choose the revocable trust structure as a way of probate avoidance, because any assets that are titled in the name of your revocable trust avoid the whole process of probate.
Great. And correct me if I'm wrong, but probate makes a will. A will in probate is not private, and a trust is. Is that correct? And so that's another, yeah.
Yeah. So the thing with probate is all of the information is part of the public record. So anybody can go down to the courthouse, pull your will off the shelf. Sometimes you have to pay a fee, sometimes you don't, but they can see who you gave your assets to and when. Whereas with a revocable trust, it's completely private. The terms of the trust are not part of the public record. And so from a privacy perspective, a lot of people choose a revocable trust just so that, their nosy neighbor doesn't get to see who got their assets after they passed away.
Great. Anything to add on this, Dominic?
I would just add that when a client does have these, it gives you a great view from a financial advisor's perspective into how they want their assets to be distributed or exactly what they care about the most. It could be charity, could be specific individuals via bequests. It could be how they feel about their children and or maybe children from a second marriage. So it can give you a lot of good questions and information to ask. And, again, back to ensuring that that's consistent with your experience with the client, encouraging them to get those documents updated if it doesn't feel like it's matching up with their.
That's a great point. Sorry. Yeah, that's a terrific point. And I have heard financial advisors say that, they've been maybe dealing with a certain class of assets, maybe investments, and until they got into estate planning, they had really no real big picture of the entire sort of portfolio that their clients had. And that really helped them shape their sort of entire financial strategy, not just estate planning. All right. Oh, see, we've already talked about. I made you jump ahead a little bit, Stephen.
Oh, no worries. I think that's an important slide though, because a lot of times people are going to get information where somebody goes, well, you need a revocable trust or you need a will, right? And so why would you choose one over the other, right? So there's three main reasons why you choose to use a revocable trust structure rather than just use the standalone will, right? And so the first one is what we just discussed on the last slide, probate avoidance, right? Any asset that you pass away with that's titled in the name of your revocable trust is going to completely avoid probate. And so in states that have a burdensome probate procedure, such as California, for instance, it's very common for people to have a revocable trust, or a lot of people in California call it a living trust, to title their assets. And so as long as you title all of your big assets in the name of your revocable trust, you're going to avoid probate, which is really important. There's also privacy, which we discussed, right? And privacy is, the terms of your will are part of the public record, and the terms of your revocable trust are not part of the public record. So if you want to keep everything private, you can use a revocable trust rather than use a will. And then finally, for a lot of clients, they don't think about, but it's really an added benefit, is incapacity, right? And so when you put and take titled assets during your lifetime in the name of your revocable trust, if you ever become incapacitated, whoever you've named as your successor trustee under your revocable trust can immediately step in and manage those assets for you. There's no going down to the courthouse to get appointed. There's no determination by a doctor that you're incapable of, making your own decisions. Your successor trustee steps in and they can kind of seamlessly manage those assets for you, continue to pay the bills, continue to provide for the people that you provided for during your lifetime, wife, kids, other people that you consider to be, dependents. They can continue to kind of just do everything seamlessly for you. So I think those are the three big reasons why people choose a revocable trust structure over just a will.
Great. So let's talk about the complexity of estate planning. I know that some folks taking this class might be intimidated by the complexity, and certainly a lot of clients are. I think that it can be can kind of make folks heads explode when they kind of get into the weeds of it. So can you talk about the complexity of estate planning and why that's kind of a challenge at some points?
Yeah, I would say, typically what you're going to see from, especially if you're a married couple and you have a taxable estate, it gets very complex very quickly, right? And the whole driver behind that complexity is tax minimization, right? And so at the death of the first spouse, you'll see here, there's various buckets that are going to be created at the death of the first spouse, right? So there's going to be an exemption trust that uses up whatever federal exemption that they have left. And then the balance is typically left to a marital trust. And the point behind that is to defer the estate tax until the death of the surviving spouse. And anything you give your spouse is exempt from estate tax. And then what you'll typically see for a married couple is at the death of the surviving spouse, kind of all of the assets. So the two buckets that are created at the death of the first spouse, and then the surviving spouse's separate assets, all pour into trust for the benefit of descendants. But the complexity here, you can see it is very evident, right? There's a waterfall, there's a bunch of buckets that are created, and I've just seen clients, their eyes glaze over, even, other investment advisors' eyes glaze over when they see this, right? And so one of the nice things about vanilla that I've noticed when I use it with my clients from who have financial advisors who use vanilla is they make the complex very simple to kind of understand and view. Exactly. So you can kind of, it takes a lot of the complexity out of the picture and makes it simple for people to understand.
Perfect. So Dominic, can you talk a little bit about this from an advisor perspective, helping sort of meeting clients where they are and helping, like, you're trying to get complex strategies across them. You need them to understand the value of what you're doing, but you also need them to sort of understand in a way that's sort of clear and not just this opaque, legalese. Can you talk a little bit about that?
Yeah, I mean, just on the prior slide, it looks like, I think that the point of this slide, and we often see these, is that this is an attorney trying to help simplify it for the client. But when you ultimately look at this, it doesn't make a lot of sense to the client. Like, okay, well, what is a formula gift? And I think I understand what tangible property is, but federal exemption, I'm not tracking here. So it's not really in their language. And even as a financial advisor, it's often like, well, what goes to who and when is probably like the bigger questions that come out of these discussions. And so on your next slide, you started with a family tree. I mean, this is a very common place. It's like, who do you care about? Okay, my kids, how are they going to fit into the overall picture? And what are they going to get? And another very common one that we use right out of vanilla is, who are the fiduciaries? Who are the people that I'm looking to make these decisions if I'm not able to and alive, or if I've passed and they need to administer my estate and be maybe a trustee for my children or for maybe other members of my family that I care about. So a lot of it's just, I think, taking those terms that might be related to what type of trust or how we're using an exemption or whatever it might be. Even smaller estates oftentimes have a diagram that looks very similar to the one that Stephen just showed, because estate tax exemptions have changed a lot over time. Right now they're very high, but at prior times it's been 1 to 3 million. So they want to make sure that the plan can withstand any exemption amount. So even a small estate could have a very complex schematic like we just saw. So again, going back to who's my family, who are the people that I'm trusting to make decisions as a starting point for a conversation that financial advisors can have is an excellent place. And that's right where most clients are at right now. And the majority of updates that need to be made or kind of attuned to are related to those items.
Do you find that some of these the simpler graphics allow you to sort of give you milestones within the conversation itself and kind of help guide the conversation along so that
100%.
you can, yeah.
And really, regardless of client size or estate complexity, everyone has the same issue. You know, most clients, they're not attorneys. Some of my clients are attorneys, but they're not. So they don't understand how this all works no matter what their net worth is. So always starting kind of from the basics is an excellent building process for them to be able to get comfortable with what they have, and then you helping them ensure that what they have is what they ultimately like to occur in their documents.
Perfect. So that wraps us up for the sort of foundational basic planning. Thank you both very much, Dominic and Stephen. And I'll remind folks out there that we do have additional resources in Vanilla Academy, articles about, we talked about probate. There's an article on probate. We talked about trusts. You'll find multiple articles about trusts. You can also find webinars and such in our resource center. So please do explore those. And please also come to the third installment of this 101 series, where we're going to talk about advanced planning for taxable estates. Thank you both very much.
Thanks.
Thanks, Dan.